What I'm going to be revealing to you today is basically the hospital's playbook on the tactics that are used in sham peer review. Why do you have to know this? If you have medical staff privileges, you need to know this because hospitals are increasingly looking for ways to control physicians on staff and to eliminate physicians whom they don't like for one reason or another, because they're competitors, because they're whistleblowers, whatever. And sham peer review is one of the techniques they use to get rid of such physicians. If you work for a large medical clinic, and to another extent, this applies to some medical boards as well. So that's what we're going to be covering today. And I want to make clear from the outset that AAPS supports peer review that is done in good faith for the purpose of furthering quality care. The only type of peer review that we oppose is the bad faith type of peer review that is done for purposes not in the furtherance of quality health care. Good faith peer review should be collegial, educational, fair, done for the purpose of improving quality care, and most importantly, it should incorporate substantive due process and fundamental fairness for the physician under review. So let's start with just the definition of sham peer review so everybody knows what it is so we're on the same page. Sham peer review is an adverse action taken in bad faith by a professional review body for some purpose other than the furtherance of quality health care, and that is disguised to look like legitimate peer review. Andy Schlafly perhaps said it best in an amicus brief that we filed recently. He filed recently on behalf of AAPS in the case involving Dr. Rakesh Wahi. We filed this amicus brief with the U.S. Supreme Court. AAPS has filed numerous amicus briefs in an attempt to assist various physicians who have been wrongfully accused and charged. Andy, in his recent amicus brief, said sham peer review is not peer review at all, but is tortious conduct labeled peer review by hospitals in order to exploit a judicially created immunity. So it's a way of hiding wrongful acts. Just one brief word about hospital contracts. For those of you who may have signed or may be thinking about signing some sort of a financial support agreement with a hospital, you need to know that if you do not perform as expected in terms of bringing in the amount of income that the hospital is expecting you to bring in, that they may look for some way to get out of that contract. And one of the easiest and most cost-effective ways to get out of such a contract with a physician is to do a sham peer review, because if you lose your hospital privileges, then you cannot fulfill the contract and the hospital doesn't owe you any money. And you should be aware that hospitals are increasingly putting language into these contracts whereby if the hospital terminates the contract, on the other hand, for any reason, that your hospital privileges are automatically terminated and you have no right to appeal under the medical staff bylaws. The thing when we started looking at these tactics that became clear early on was that these tactics that hospitals are using in sham peer review are remarkably similar throughout the country. And basically, these tactics are tactics which violate due process and fundamental fairness and are often designed to make the event fit the crime. This following list of tactics that I'm going to be revealing to you today, the hospital playbook on sham peer review, you should realize is not an all-inclusive list. There are many tactics that we've identified. These are just some of them. The ambush tactic is fairly common. This is where someone from the hospital administration invites you into an informal, friendly meeting. You're not told who's going to be at the meeting, nor are you told what the meeting is exactly about. And you end up getting into the meeting and find yourself sitting across the table from the CEO of the hospital, the vice president of medical affairs, the chief of staff, and perhaps the hospital attorney about issues that everyone else in the room knows about and you know nothing about. And of course, that's part of the idea behind the ambush tactic, is it's designed to induce shock and awe in the physician who's sitting in front of this panel because he or she has no idea what to expect. So what should you do if you get an invitation to one of these informal, friendly meetings? Well, you should take a trusted friend with you to the meeting who would be willing to testify as to what was actually said at the meeting. Another thing you can do is take one of these little recording devices. They now make video and audio recording devices in the form of a pen that you can place in your pocket. They even have this wonderful pair of sunglasses you can go in wearing, looking real cool with sunglasses on, that has video right in the bridge of the nose there. You should check the AAPS website, the link that's shown there. It has the requirements, consent for taping requirements by state, so you can check to see if you're a one-party or two-party state. Depriving the accused physician of charts, complaints, instant reports, he needs to defend himself. This is a pretty common sham peer review tactic. They tell the doctor, you know what, we have a concern with 20 patients that we've looked at, and we think there's a real problem there. And they don't provide the charts to the physician so the physician can review them so as to be able to defend himself. And sometimes they wait until the physician gets in the peer review hearing itself, and then they give the physician the charts, and of course he doesn't have time to review them at that point. And as he fumbles through the stack of 20 charts, he looks guilty, which again is part of the idea behind the tactic. What you should do is document requests for pertinent records in writing, and your attorney should document a strong objection to this tactic whenever it's used. So at least there's some objection on the record that they have not been fundamentally fair to you by providing you the records that you need to defend yourself. Physician is presumed guilty prior to any peer review hearing, and the burden is placed on the physician to prove his innocence. Hospitals frequently will manipulate the medical staff bylaws to incorporate a guilty until proven innocent provision in peer review that they refer to as a fair hearing. The hospital then basically offers the Nuremberg defense that they were just following the bylaws when they considered the physician guilty unless he can prove his innocence. Numerator without denominator tactic. This tactic is most often used against surgeons, and it basically comes from the idea that all surgeons who perform surgery are going to have complications at some point. The only surgeons who don't have complications are those who don't perform surgery or who do not report their complications. So what some of these hospitals do is they will say, look, this surgeon had 5 complications during the past year, and we think that's terrible. It's not within the standard of care, and we need to do something to him. What's missing in that is, of course, the denominator. How many surgeries of that type did the surgeon do during the past year? If he did 5,000 surgeries and he had 5 complications, that's a lot different than if he did 25 surgeries and he had 5 complications. The hospital deliberately does not provide the denominator in those cases so they can make the physician look terrible just based on some absolute number. And again, the thing that we do compare are complication rates among surgeons in the same hospital, complication rates that are published in the literature for certain procedures, and that's the part that's missing in this tactic. Misrepresenting the standard of care. This is something, again, that hospitals do use frequently. And we recognize that reasonable and competent physicians can have legitimate professional differences of opinion about the optimal way to treat specific patients with specific conditions. But what happens is often is the hospital will go out and hire an expert, and the expert said, you know what? I wouldn't have done that surgery this way. I would have used another technique. I wouldn't have done it that way. And because the surgeon under review didn't do it my way, he's practicing beneath the standard of care. So it ignores the concept that reasonable and competent physicians often legitimately disagree on the optimal way to approach a particular case. It's simply a legitimate professional difference of opinion. I've even seen one case where the hospital basically offered the idea that because the physician did not follow the Medicare billing guidelines, that he was practicing beneath the standard of care. So in that case, the Medicare billing guidelines were used as a standard of care, which is totally inappropriate. False and or trumped up charges. And again, this is a whole slew of different things. Oftentimes, a hospital will bring into a committee meeting an entire stack of complaints or incident reports. They will point to this stack and say, look at all these incident reports and complaints that are due to this one physician. we have to do something to protect patients. And of course, the people sitting around the table, the other doctors say, yeah, that's a pretty impressive stack of incident reports and complaints. The problem is, oftentimes, the physicians sitting around the table, the peer reviewers, whether they're on a peer review panel or a medical executive committee, often do not perform due diligence. They don't even look at the individual things in that stack to see, are they really legitimate incident reports or complaints, or are they something else? When we've looked at some of these, we've found that the stack that they're pointing to sometimes have included compliments concerning the doctor's care and things like that. But again, often what happens is you'll have a choreographer, someone in the hospital administration, associated with the hospital administration, that is providing this summary type information to the peer reviewers, and the peer reviewers simply defer to whatever the summary information is.